The cases that actually go to trial are the ones in which the facts are not conclusive, or where your presentation of them is weak, or where the evidence seems questionable, where there have been conflicting results or testimony. You may be completely convinced of your results and your conclusions, but you would not be in court if everyone else agreed with you. Somebody else will now decide whose facts and opinions seem to be the most believable. As a key tactic then, in court your facts should be correct, but it is equally important that you sound and look convincing when you present those facts. The lawyers have their shot at convincing the jury in a variety of ways, and usually over several days. You have your shot once. Just remember that it does not matter if you think you are right. You have to convince the jury in the limited minutes or hours of your testimony that they should believe what you have to say. Now, leading up to your testimony, the preceding lesson discussed the many preparations that you must make in the days or weeks that just precede trial testimony. Let me share with you some things that you should think about in the immediate 24 hours preceding your testimony. Because of delayed or canceled flights, traveling by airplane on the day before trial testimony can be stressful. If you are an out-of-town expert, you should consider traveling 1 to 2 days before trial testimony so that you arrive early and are calm by the time of the trial. An important tactic then is to try to schedule a pre-trial conference with your attorney on the day before trial. You then can readily do your traveling either that morning or the preceding day. You can use the day before the trial itself to review important materials and to have a pre-trial meeting with your retaining attorney. Getting a good night's sleep is always beneficial, and particularly so the night before trial. Some people suggest that you do not drink any alcohol the night before trial, but you should know yourself well enough to make your own decision in that regard. If you are taking any prescription medicine, you should discuss that also with your attorney, since it might have an effect on your energy level during an intense trial day. The attorney might be able to, or choose to, adjust the order in which he calls witnesses, so that he can call you earlier in the day. As I suggested in the discussions earlier about deposition testimony, do not take anything up to the witness box that you do not explicitly need during your testimony. If you feel that you need your entire file folder with you for reference, you should ask your attorney to review it, once again, to make sure that nothing of a privileged nature remains in it. Remember that dressing conservatively conveys professionalism. You should comb your hair, and you should make sure that your clothing is clean, neat, and freshly pressed, if it needs pressing. When on the stand, you should restrict unnecessary movement. Do not look fidgety if possible. Eliminate any frequent tics if possible. And finally, you should just sit up straight. No slouching, no hunching. Your personal bearing can have an incredibly positive effect on the sense that jurors and everyone else in the courtroom will have of you as a credible, professional, and authoritative expert witness. A minor tactic to think about: if you carry any papers or your file folder to the witness stand, carry them in your left hand. When you raise your right hand to take the oath, you won't have to switch papers from one hand to the other and take even the smallest chance of dropping any of them at that moment. Let's talk about some of the characteristics of your testimony now. The opinions that you express have to follow naturally from the work that you perform. This work has to consist of investigations, analyses, tests, or reconstructions and other discoveries that are relevant to the case. In total, These constitute the reliable and defensible foundation for your opinions. You will have to demonstrate that any technical assumptions you made are scientifically valid and meet judicial standards regarding peer review. Jurors expect that experts come to testify with opinions that support the side that hired them. Otherwise, why would they be testifying? However, they still have to be convinced that you are making the same claims as the attorney on your side because you truly believe what you are saying. You have the important job of convincing the jury that you joined the case to investigate independently and to evaluate the facts. You performed tests of your own choosing and eventually reached the supportable and defensible positions that you are now presenting to them. First, the jurors have to be convinced that you even deserve their confidence. You obviously have to have the experience or knowledge or credentials necessary to do what you say you have done. Second, you have to understand fully the elements of the case and have taken all the necessary and appropriate steps and have selected industry-accepted methods to follow. In short, you have to exude confidence that you have done these things and that you understand them, and that altogether they led to your opinions. People do not like to listen to boring people, especially boring witnesses if they're stuck in a jury box. This has nothing to do with your competence or qualifications. It has everything to do with effectiveness in court. A great expert witness, like a great teacher, sounds natural when he speaks and appears personable and likable. He chooses words that are easy to understand, along with explanations that use interesting analogies or examples. He entertains with his voice and with any demonstrative exhibits that he has created. As an important tactic, the expert witness has to be honest about what he knows, yet confident about what he doesn't know. Ideally, you want to have a human side that will make the jurors think back to a favorite teacher years earlier. A good way to do this is to simply sound warm and at the same time to be enthusiastic about what you are presenting. The bottom line is that you have to persuade your listeners that your opinions and conclusions are the right or the better ones. Some jurors will already have an opinion about the case by the time you testify. Others will have no opinion. It doesn't matter which, you still have to persuade those jurors that your opinions are correct. Logic and facts presented by you will rarely be enough. Effective persuasion depends on the elements I've just discussed. Your work has to be technically solid. Your presentation of it has to be professional and believable. You personally have to be likable and perhaps a little entertaining, and the jurors have to conclude that you are honest and competent. No small chore, but this lesson is about how to do just that.